Yeah. Except for
You didn't get the memo.
story of my life. It's all right. So getting 10 morals, when walls.
Matt, were you waiting for us or are we waiting for you? Or are we waiting for the clock?
No, I'm trying to figure out something here.
Okay, whenever you're ready, you let us know.
Yes.
Oh, here it is.
The three dots on the folder.
You know what?
Oh, there again, drop down. People feel like that's
Select that.
Right.
discussing Shakespeare
After all,
as we do.
yes, as is our regular practice up here. We're only doing Shakespeare because we're up here on the stage. If we were down there, we'd be quoting somebody else. What was his man?
Okay, planning board, I just want to let
Ready?
you know
Mm-hmm.
that for whatever reason, we're channel 22 is the video is a little haywire right now. I'm not sure, but we are broadcasting on YouTube very well, and I can hear the audio very well. So if the audience can turn into YouTube, that would be fantastic. And I have
Maybe you want to,
let our chief engineer know just what's going on.
Matt, maybe you can run a Chiron or something that tells folks that also.
Well, I have
up
the
to you. I'm not
broadcast.
gonna tell
I
you how
have
to
the
do your
broadcast right now. It's just not clear on channel 22. And I'm going to change this right now to that.
So Matt, can you just put on under the planning board, tune into YouTube if not getting good reception or something? on
Yes. Yes.
Then put,
Thank you.
and put the
So
URL.
let's continue, and people can watch on YouTube because it is live on YouTube right now.
Very good.
So go ahead.
Yeah, just before we get started, just make sure that Jody didn't get herself locked out. Okay,
There's-
good. All right, good, good.
I was on cue. She's well rehearsed.
Right there. Water in hand.
Okay. Sam, whenever you're ready. Sam, whenever you're ready, go ahead. It's on YouTube.
Very well. Good evening and welcome to the Town of East Hampton Planning Board meeting for August 28th, 2024. We have a number of matters on for work session and a couple of resolutions in the regular meeting. I anticipate that after the meeting, there will be an attorney consultation which will go forward, not broadcast. So the first matter that we have on is, I hope I don't mispronounce ECO when it should be Echo Acres. Dan, you've got that one, and Ed, you've got that. And is the applicant here on that's yours here for that? Very well. Okay, go ahead.
Thank you very much. All right. Hi, well, good evening, Mr. Chairman and the
A
planning.
little louder.
Oh, is that better?
Yeah.
Okay.
Thank you.
No problem. So this is an application to subdivide an approximately 6.722 acre lot having frontage on both Bull Path and Old Northwest Road into two individual lots, one of which is approximately just over 137,000 square feet in size, and the other of which is approximately 142,000 square feet in size. Two scenic easement areas are also proposed in addition to a 12,890 square foot access easement off of Old Northwest Road.
Dan, I'm still having a hard time hearing you. Is anyone
That mic.
Bring it right up.
to bring the
close.
mic right up to you? I think.
Cracker Jack technology required.
Backward, is that
There you are.
better?
Thank you.
I think so. Yeah.
Okay. All right. So the site is a vacant lot, as you can see from the aerial. It's a vacant lot located within the E3 resident zoning district. The lot is located within several areas of important environmental consideration, which including the Suffolk County Pine Barren Region Groundwater Management Zone 5 and the town's water recharge overlay district, all of which identify the parcel's importance to groundwater protection and recharge of the town's sole source aquifer. In terms of the existing vegetation, it appears that the site is substantially wooded and is considered only to be partially cleared of natural vegetation per the town's records. Finally, just as a side note, a natural resource special permit jurisdiction memo dated October 27th indicated that extensive excavation was conducted on the project site. Additional areas of seeding ponding were also noted during this assessment, which are further discussed throughout the evaluation. So kind of giving background into this application. So the proposed subwaiver itself was actually previously reviewed by the planning department for the May 15th, 2024 planning board meeting. This is actually the second evaluation that we've conducted of this project. The original one at the time, we had several comments issued to the applicants at the time, which primarily pertained to lot dimensions, site access, water supply, utilities, and clearing. However, it was also indicated that the proposed design, layout, and access location of the two-lot subwaiver as originally presented, which we will be able to pull up here. 1 second. So this is actually the first submission, the original one, we found generally to be acceptable, particularly in relation to the town code and board policies. However, despite the recommendations we made during the previous evaluation, the applicants did request to adjourn the project, primarily to address the complexity of the matters raised in the memo, as they've indicated. This adjournment was obviously subsequently granted, and then they have since submitted this new application. So with this most recent submission, there have been several changes to the subdivision subwaiver layout as proposed. As we noted, compared to our previous recommendations, we did find some of these to be inconsistent with recommendations we made during the previous evaluation. And we found the previous design to be more conforming with respect to town code and board policies. Therefore, given the dramatic changes that have been done to several changes that have been done to the project throughout this, we're kind of recommending that the primary focus of the review today should really center around whether or not the overall layout, the lot sizes, the reserved areas as currently presented are acceptable to the planning board, or whether the previous design that was been submitted was more acceptable. So getting into kind of just a couple general comments that we've had for this new proposal that's been submitted. Similar to the previous submission, there was, to us, didn't appear that there was enough information provided with respect to why the two lots and the scenic easement areas as currently presented have been reconfigured in the manner currently presented. The cover letter does state, again, as many changes have been made in order to respond to our previous assessment of the project. However, the initial feedback had endorsed the original proposal, which has been, and this project has been revised in matter, again, a little different than we originally had advised. However, as noted during that previous evaluation and this one, given that the site is located within the A3 resident zoning district and the water recharge overlay district, it is appropriate. The project is required to be an open space subdivision, which, based on our review of this project, it does appear the project has still been designed with respect to those requirements of the town code, which was appropriate for this project. Now, in terms of the changes to the project itself, one of the biggest changes we noticed, so again, I guess bring back. So the lot size itself, the overall parcel is about 292,793 square feet, again, within the A3 resident zoning district. Now, with this most recent submission, the major note we did have is that the lots are now proposed to be substantially increased in size compared to the previous proposal. It was noted during the previous evaluation, the proposed lots 1 and 2 were approximately between 35,000 and 44,000 square feet in size. With this submission, the minimum is 137,000 square feet and 142,000 square feet for the two proposed lots. Again, so unlike the previous submission, it's actually noticed that the A3 resident zoning district has a minimum lot area requirement of 125,000 square feet. The previous design didn't meet those standards. However, we did note that pursuant to the open space subdivision code, the planning board does have the authority to modify the town's residential dimensional regulations in order to achieve the purposes and objectives of that code. We did attach it to this memo, and it's referenced, throughout the previous memo as well. So that was still possible. However, this new proposal does negate any potential need to reconfigure the town's residential dimensional regulations or potential variances that could be involved with this, should the board not find it to be, accepting of the smaller lot size. Additionally, we also noted that there's town code 221.06H specifically prohibits areas of greater than 20% slopes from being utilized as buildable area. As you can see from this subdivision map being showed, there are areas of substantial steep slopes within the rear of the property, assumably related to the previous activities that were conducted on the project site. These are the areas that are kind of highlighted in orange here. Now, we did note that for this current proposal, there is a building envelope which illustrates that the building envelopes exclude the areas of these slopes, which is appropriate and consistent with the town code. So you can see there's kind of if I zoom in a bit, there's building envelopes within both of these lots that typically avoid these areas. Two slopes. However, the Although we did find this to be appropriate, we did note that the calculations on the survey have not been adjusted to remove the areas of steep slopes from, or appear to not have been adjusted to remove the areas of steep slopes from the calculations. And again, based on the town code, this is something that typically wouldn't be, has to be done. It would be not removed from the lot area calculations as currently configured. We did note also that the previous proposal had the areas with 20% slopes within the reserved areas, which from a planning perspective, we found to be a better configuration. Just to go back to that previous plan, you can see here that where the proposed lot 2 is now was substantially proposed as reserved area B. And it consisted of all the steep slopes where now some of those are considered within, the current proposed lot 2. However, the building envelope is also not located, avoids those steep slopes. So we also noted too that the current proposal includes a driveway that must be constructed directly through the area where steep slopes 20% are located, which potentially challenge to the application that doesn't appear to have been directly addressed as of this most recent submission. However, I will note that the applicants have always indicated us since then that this has been, the driveway is actually considered, is existing already on the lot. We haven't had a chance to go out there and inspect it yet, but just as a point of record. Now, the other major comment we had with this has to do with the reserved area requirements. Pursuant to the town code, it's noted that any property within the A3 residence zoning district and the water recharge overlay district shall preserve approximately 60% of the overall lot area for open space subdivision. Now, during the previous review, it was noted that the overall area that was proposed to be reserved was approximately 193,000, just over 193,000 square feet, or about 4.4 acres, which constitute approximately 66% of the total site acreage through 3 individual reserved areas, which are located in the rear, property's frontage, and actually there was one in between the lots. However, with this most recent submission, the proposed subwaiver has been modified to include 2 large scenic easement areas along the property's frontage on both Bold Path and Old Northwest Road. Each one is approximately front-facing one for Old Northwest Road is approximately 90,000 square feet in size, or just over it, and the rear one is about 85,000 square feet in size, respectively, which has been estimated by us to represent approximately 60%. So still meeting the town code, just slightly reduced from the previous submission. Now, with respect to the project and area, we recommend requesting the applicant to explain kind of their decision to replace the 3 reserved areas with the 2 large scenic easement areas, particularly given that some of the areas of steep slopes, which are previously proposed to be reserved, are now kind of being incorporated into the lot areas of the lots, specifically the rear lot 2. Is already just saying that per requirements issued in the town code, which are further referenced in the memo, in order to ensure that these areas to be conserved continue to perform their required function, proposing these as reserved areas would particularly be more appropriate. And again, as a reminder, as we've indicated last time, when a reserve area is set aside, fee title of the reserved area must be vested to one or more following entities, including properties owner association, the town of East Hampton, or private conservation corporation. And we requested that if they are to be revised to reserved areas, the applicant should specify who the entity that will take title to this reserved area. And additionally, finally, we've indicated that the size, including the size, percentage of reserved areas, should be overall indicated on the plans. So just to reiterate, as we previously indicated during the previous review, the scenic and site quality of Old Northwest Road and Bold Path are important to preserve in this location, and that maintaining greenery along the property's frontage is appropriate consideration for this project. However, as stated in the introduction for this analysis, we think the major focus really should be kind of the board providing comments to the applicants whether or not the layout, the lot sizes, and the reserve areas allocation in general are acceptable. And given that there's without further explanation or support of the current proposal, we recommend that the previous design was more appropriate for the project site. And we recommend consider the board or not agrees.
Thanks very much. That was a multi-layered report, and we appreciate that. Mr. Tarbett?
Hi, John Tarbett for the applicant. So Daniel did a good job recapping the history of the site and the project. This was an old sand mine, in case anybody missed that. Yeah. So the steep slopes, while probably somewhat natural, are mostly man-made. We did design the application to protect 60% of the property in perpetuity, which is a requirement of the town code. And we located those protected areas along both Old Northwest and Bull Path. So if you were driving down any of the public streets, you would have this big open area which is preserved, and the lots, the two lots out of the almost nearly 7 acres, are interior lots. We would have, quite frankly, preferred to come off of Bull Path if for reasons just I think Bull Path might have a nicer address than Old Northwest, but we realized that probably wouldn't be something the planning department or maybe the planning board would appreciate, just because of the clearing necessary and driveways. So what we did is we utilized the driveway that was there for the mining operation for over 60 years. So if you look at aerial photographs, you can see that the proposed driveway has just been there for 60 plus years, as far back as the aerial photographs as you can see. Again, it was our mistake when we initially submitted the application. We thought we had to use reserved areas. So we designed the application to use reserved areas. It was the planning department's memo for the May hearing, which came out and said that you could actually use scenic easements, which Chairman Kramer, you would understand, setting up HOAs and dealing with HOAs is a lawyer's worst nightmare, especially if it's a 2-lot subdivision. So quite frankly, to not have to do an HOA and be able to accomplish the same goal with the scenic easement just made perfect sense to us. The town attorney's office could advise you, but it's my opinion that there's no legal difference between a reserved area and a scenic easement with regard to protecting property. The scenic easement is a covenant or a grant to the town of East Hampton, which it can enforce and inspect on a yearly basis. So I don't know if there's a difference. And did you think there was a difference? Or
You're asking me?
oh, you shook your head, so I wasn't sure.
No, well, I don't want to do a lawyer thing here, but I can see I definitely see a distinction between the two. But again, it's not that I don't know that that's necessarily decisive for us today.
Yeah. Okay.
So,
Yeah. No. As far as I can tell, and I am a lawyer, and I do a lot of real estate law as well as zoning law, and to me, they're both designed to protect property from being built on. And they accomplish the same thing through slightly different legal mechanism. One, an HOA would be owned by either the developer in perpetuity, or it would be granted or sold separately as an individual tax lot. Whereas a scenic easement will be, the 2 lots will each have the scenic easement within their property. So they'll be owned by the people who buy the lots. It's just a slightly different way of cutting the cake.
yeah, no, there's that happens a lot in the law, where, the end result ends up being the same. The problem could be if there is ever an enforcement issue or a litigation issue, how much trouble is the litigant who's trying to enforce the thing, whether it's an HOA covenant or something else, is going to have to deal with.
Well, we have all those HOAs in Montauk that were from the subdivisions from the 50s and 60s, which the developer disappeared, and the HOAs are unowned. So somebody goes in and clears them. Whereas if the protected area is owned by the properties in a scenic easement, then that's enforceable directly against the property owner. So there's probably arguments that a scenic easement is better. As a matter of fact, the town code actually requires that areas with 20% slopes be put into a scenic easement, not a reserved area. So in doing our homework after look at this, we realized that we actually weren't in compliance with the town code by putting the 20% slopes in a reserved area. So we reconfigured the lots to put them in a scenic easement.
So may I interject just a little bit? I'm sorry. This is Tina Laundrette.
Usually we'd wait until I'm done, but.
Oh, okay, just because we're talking a lot about this and there was a bit of a, I think, miscommunication.
Okay.
But if you want to continue,
go ahead.
I'll wait.
I'll wait.
Just to clarify regarding I'll speak from here. It's our understanding that reserved areas are required. It's in the subdivision code. And the reference to using scenic easements to protect areas was not meant to replace the reserved area as the tool. So, we can look into this a little bit more, but we've had this confusion happen on other applications where scenic easements were being recommended. And then it was confirmed, no, the reserved area is the appropriate mechanism. I can give the citation of code to you, Mr. Tarbett, and, you know.
You know what it amounts to? It's kind of a balancing act of the convenience of the applicant versus the necessity of,
I believe the plan department has now said that legally it has to be a reserved area, so maybe we should stop the discussion until the legal questions, because obviously if I can't legally do scenic easements, then that's a waste of time, everybody's time.
planning department taking that position?
It's my I'm not an attorney. It is my understanding that that's the way Section 220 has been interpreted. So we can confirm that offline. I mean, I could bring the language up, but why
Well,
don't we send it to you?
the plan department's memo
Yep.
from May actually suggested that scenic easements weren't allowed.
Right, yeah,
So
and
you're backtracking.
I'm saying that was an error.
Okay, well, that's the first I'm hearing that, and it's a non-legal opinion, but we can
Well-
wait until that's sorted with the town attorney's office to come back.
Are there other issues that we should be dealing with, or is that a showstopper?
Well, it's a showstopper, right? If we have proposed a subdivision that includes scenic easements as a way to protect the land, tonight, for the first time, contrary to the plan department's previous opinion, they're now saying that legally you cannot do that under the town code. I don't see that code section, but I guess it's something we'll
All
have
right,
to.
well, Ed, before we adjourn.
Yeah, no, I think we need clarity on that. We really do.
Showstopper.
I will say though, and I'm not proposing that this is the way you want to go, but I do believe that you could also, if reserve area is the way that we all determine this has to be protected, this can be vested to a conservation organization too. It doesn't have, you don't have to create an HOA necessarily, right? There are other ways to go about
Good
this, I
point.
believe.
That's consistent with the code section.
Right.
The code
That
section
would-
does provide that example. We don't want to deed it out.
Yeah, no, that was something you'd have to
Yeah.
investigate and decide
Saying,
whether you want to do, but,
Yeah.
Yeah.
It hadn't yet come up, but yeah, I don't think we go forward until we have
all
some
right,
clarity
well,
on
if
this.
that's
It's a
the,
shame because they've written 2 memos and it came up tonight at the public hearing.
well, it's not a public
Their
hearing,
previous
but,
memos.
look, it's a work session, and,
It just would've been
we
something we could've looked
work these things through in the work sessions. I'm sorry if there has been contradiction, in the memos, but, what we're doing is permanent, and so we do, it is important to get it right. I'm kind of trying to figure out why is Bull Path any more bucolic sounding a name than Old Northwest Road, but,
It's less traffic.
no, okay, well, that's something else. But, certainly is, I would think it's certainly less
This is
traffic.
right next to the entrance, is near the firehouse.
Yeah, no, I know
Yeah.
exactly where this parcel is. So, Nancy, Marshall, we're going to need an opinion.
I actually just curious, so would you, if it was reserved area versus scenic easement, would that determine the design that you're going with? Like the way you're going to parse out the 2 lots?
We'd probably have to go back to the original layout if you couldn't do it by scenic easement.
Right, that's what I was curious,
Yeah.
okay.
Could you-
This was preferable for a number of reasons.
I just before we adjourn or put this over, could you just show both alternatives? And because I want to make sure that if,
That's the
depending
first.
upon what the advice of counsel leads us, that we are looking at one or the other. Or might there be further
No,
modifications?
there shouldn't be any more. No.
Okay, so Dan, just, A/B us.
This is the first one.
This is the first, right? This is the original?
Yeah,
Keep in mind that the initial application either needed what essentially is a variance from the planning board to go forward, or possibly a zoning board variance. The new application, the way we designed it this time, didn't
I thought
need
we-
any relief from the planning board.
Does it need a
Right,
variance?
say that
there's a
again.
town code that gives you guys the authority to
Yeah. I think
change
you have
the
the
amendment
authority.
yourself.
Lots have to be 125,000
Right,
square
no,
feet.
yeah, no, they're-
Our previous, the initial submission didn't have that, and you guys have the right to waive the requirement that it be 125,000 square feet.
right.
But it does require subjective, as a right subdivision, but it would not have been under the initial application. The current application actually meets all of code, so it's as of right.
Okay, so that's the old. Now let's see
And can I just point out in the old quickly?
Please.
So one of the disadvantages from a planning perspective of the old was that you're familiar with the concept that when you do reserved areas, you want to keep them contiguous and not
yeah,
bifurcated.
no,
So the initial application had part of the reserved area between the 2 lots. So lot 1 and 2, there's a reserved area right between them,
right.
which cuts up, you want your 60% to be contiguous as much as
Can you put
possible.
the cursor, someone, on exactly where
Right
the
there.
reserve areas are?
Right in the
So,
middle.
yeah, so there's one right here.
Okay, yeah, okay.
Then there's one up front,
To the front,
Okay.
and one back
the
here.
2 lots
And
in
then where's the third one?
That big,
the back.
The whole back.
that whole big parcel, that,
Big back.
and that backs
Got
up Bull Path, right?
Correct.
Yes.
Yeah.
Which is also about 30 feet lower than the other end of the property, right?
At
Or
least
some-
30 feet, yeah.
That's where it was mined out. right?
Yeah, that's,
I would think.
yeah,
That's what that big
or at least partially.
partial, yeah, right. No, not the whole thing. All right. And Dan, just show us the other one. So
So this is the most recent.
that's, all right.
So I do object, the plan department started their presentation by saying that the old application was more in keeping with the town code and with the board's policies, but that's just a conclusory statement, right? They weren't able to describe how, and what I'm pointing out to you is that the current application before the board is actually more in keeping with the town code because we do not need that subjective waiver. And also we keep all the reserved areas in contiguous, non-bifurcated land. There's actually while they say it's not as in keeping with the town code or the board's policies, that's just a global statement. There's no actual suggestion for why it's not.
Well, let me ask the board this, all things being equal, assuming that there isn't a legal issue, do we have a preference as between the two? Or we want to wait on that,
Let's wait.
right?
Yeah.
Yeah, I don't want to give false
I don't
hope.
want to, yeah, it's not
Yeah.
wise, I don't think.
Yeah, you're right.
I did submit a memo very late today, so perhaps the adjournment gives you a chance to read the memo. as
Now,
well.
if you did, thank you. Okay. In that case, all the more reason. I tell you what, Nancy, if you can get the town attorney's office to do
Definitely,
this
yes.
right quick, and we'll get the application back on as quickly as we can, and we'll all read your memo.
I appreciate the time.
Thank you.
Thank you.
Thanks, John.
We appreciate it. Thank you. Okay. All right. We'll move on to,
Excuse me one
All
second,
right.
Sam, planning board.
yeah,
Just
Yes,
want to
yes.
make it clear for the record that channel 22 is back up and running. And
good.
just want to also make sure that we have no public comments, so the phone lines will remain off. Thank you.
All right, very good. Are you here on the Sidoric matter, sir?
Property.
I'm sorry? McGee, okay, very good.
Yeah.
McGee. Oh, McGee,
Now I think it's.
way down at the bottom. Okay. All right. The applicant isn't here on Sidoric. And the applicant doesn't want to be, we haven't received notification that they want to be here over the air. Okay, so we can, but they do know that the application is on.
She called and said, right? She wasn't going to be here?
Wiltshire said,
Yeah,
okay,
yeah.
all right. And just so that everyone knows, before we go forward with it, a few years ago, I represented a client who was in litigation with an entity owned by the owner of Seaside 63 LLC, which is the applicant. That matter was resolved and has no bearing at all on this application, and it will not impact my ability to consider this application. So with that caveat, Chris, you can take it away.
Thank you. All right, Chris Decker, planner for the town. So today we'll be going over Sidorak and Decker. It's a final sub-waiver modification. The two subject properties are located at 63 and 65 Seaside Avenue in Montauk. And just to zoom out for a little context, that's Ditch Plains Beach nearby. It's on the south side of 27. So the subject properties 63 and 65 are zoned B residential. 63 Seaside Avenue is 33,329 square feet or 0.77 acres, and 65 Seaside Avenue is 32,062 feet or 0.74 acres. Seaside Avenue is a dirt road with public water access. Freshwater wetlands cross both properties, and driveway access to 63 Seaside Avenue. The flag lot cannot be established without crossing the wetlands, which are indicated in blue here. Both subject parcels are in the Water Protection District, which makes them eligible for the Sanitary System Updated Incentive Program. And moving into the application itself. So the modification application has been made seeking relief of covenants from the conditions of approval recorded under the original sub-waiver approval dated August 10th, 1977. Specifically, the applicant seeks relief from the requirement for the subject properties, 63 and 65 here, to only be served by one common access driveway that would serve the two lots. Instead, the applicant intends for 63 Seaside Avenue, which is the vacant flag lot, to share an existing common driveway and bridge presently serving the neighboring 59 and 61 Seaside Avenue. Just note that that existing common driveway is circled in yellow on this map. The reason to avoid clearing wetlands, the reason is to avoid clearing wetlands to create a new driveway to that flag lot. Currently, 63 Seaside is not served by any driveway, and 65 Seaside Avenue has a small driveway with direct access to Seaside Avenue. That's circled in red. This would require extensive expansion in order to serve 63 Seaside Avenue. So going over the issues for discussions, change in circumstance. It's an established planning board policy that in order to review a prior subdivision approval, the planning board must determine that there has been a change in circumstances that warrants looking at the approval again. If the planning board determines that the change in circumstances is existing, then the board must review the modification and determine whether it's consistent with the town's subdivision regulations. So the planning board should discuss whether the implementation of restrictions for developing near wetlands establishes a change in circumstances. The subject parcels were created under the subdivision subwaiver approved in 1977 before modern requirements for natural resource special permits were implemented. Since this time, the town has put more of an emphasis on the protection of natural resources, and the planning department recommends that the construction of a driveway through wetlands is not appropriate based on modern standards, and that consideration of other alternatives is. The planning board should, if they agree this constitutes a sufficient change of circumstances, give consideration to the environmental protections in place and whether it is in the interest of good planning for 63 Seaside Avenue to share the existing common driveway currently serving 59 and 61. So those are the two properties just to the north here. They're all highlighted in cyan. The planning department also notes that the subwaiver approved August 10, 1977 had a previous modification related to driveway access, which was adopted that September 14th, 1977. So for this, the owner modified the approval to relocate the driveway access near the northern property line of 63 Seaside Avenue, whereas it was originally planned toward the southern property line. Currently, the northern property line has the pole access to the flag lot 63 Seaside Avenue, and the driveway serving 61 Seaside Avenue encroaches the mentioned property line. That's visible here along that line.
Is 61 the one that runs the entire length of?
Yes, 61 and 59 both run the length.
You know, I don't-
65 and 63 were created out of similar lots. So originally,
Right.
63 and 65 were three thin, long parcels, which the subwaiver established these two larger lots.
Thanks.
The planning board should discuss whether the construction of the common driveway serving 59 and 61 Seaside Avenue, which encroaches on 63 Seaside Avenue, establishes a change in circumstance for ease of access and improved planning. Regarding issues related to the wetlands, constructing a new common driveway for the subject parcels would impact the wetlands on site. Currently, and as mentioned, 65 Seaside Avenue is served by a small driveway that does not impact any wetlands. And again, that's the one circled in red. Meanwhile, the neighboring 59 and 61 Seaside Avenue are served by a common driveway with a bridge over the drainage course. Part of the driveway serving 61 encroaches into 63 and has potential for expansion to serve 63 Seaside Avenue, the subject property. So the planning board should discuss whether using the existing common driveway to serve 63 is in the interest of good planning to preserve to the extent possible the existing wetlands. Regarding issues of common driveway access. In the original subdivision, because 63 Seaside Avenue did not share a common access with 59 and 61 Seaside Avenue, the subject parcel currently has no right to access that driveway. Although 61, which is the immediately adjacent property, and 63 Seaside Avenue are owned by the same person, written consent from 61 Seaside must be provided given the properties are owned in two separate entities. Regarding 59 Seaside Avenue, the applicant has not indicated that any discussions with that owner have occurred. Although the portion of the common driveway that 63 Seaside Avenue would use is not within the boundaries of 59 Seaside Avenue, the common driveway access would be expanded to a new property. A new common driveway easement should be mapped on the properties to clearly establish access and maintenance responsibilities. In addition, the applicant has not identified if they've allowed permission for the driveway serving 61 Seaside Avenue to encroach into their property. The applicant's now advised about other approvals that following additional approval will be required if the existing common driveway is expanded to serve 63 Seaside, and that would be through the Zoning Board of Appeals, the ZBA. It would be within NRSP jurisdiction and would require that natural resource special permit to clear or grade land and build any structures or improvements within 150 feet of the mentioned wetlands. Importantly, the final driveway configuration should seek to minimize wetland disturbance. A last issue regarding title plans. All plans submitted for this application should be using a consistent naming as well as correspondence for the application. And then moving on to the conclusion, the planning department notes that allowing 63 Seaside Avenue to share the common driveway currently serving 59 and 61 Seaside Avenue would appear to be the option that would have a smaller environmental impact than constructing a new driveway. Any planning for the detailed design would need to make protection of wetlands a priority in the design. And prior to detailed planning, the permission of 59 and 61 Seaside Avenue must be sought. Planning department recommends that minimizing disturbance to wetlands is in the interest of good planning, and that modern emphasis on this important goal was not well established in 1977 as it is by today's standards. If a change of circumstances is established, the planning board should consider allowing the applicant to explore the alternative of sharing a driveway with the adjacent properties, pending confirmation that the property owners would give formal consent to do so. If such is not possible, alternatives will need to be considered. In order to confirm alternatives, the extent of wetlands along the lot at 63 and 65 Seaside Avenue, the subject properties, will need consideration. And if the board requires additional information, the planning department advises the applicant to submit revised additional plans and a response letter that meets the requirements listed in the evaluation.
Thanks very much. There's a lot of, we're kind of on shorthanded here. This was Lou's, aside from not having the applicant here, this is Lou's matter, and I hadn't realized that Lou was not going to be with us tonight. So we can, I think we should probably, as an initial matter, come to an agreement or consensus as to whether or not there's been a change in circumstances. We've in the past looked at changes in the law.
Yeah, I mean, I think you made a good case for a change of circumstances, being that this was originally, done in 1977 and things have changed since then.
And the proposal,
This
do
was
we
an
all agree
old
on?
subdivision that,
Agree all around on that? That is a change?
Yes, I
Okay,
can.
all right, okay. So we all,
Articulate the change in circumstances exactly, though.
well, the change of circumstances that this was an old subdivision map that occurred in 1977. And now it just doesn't make sense to make the driveway where they originally thought, because it just goes through a whole swath of wetland where they already have a driveway that goes through that piece of wetland, and all they have to do is extend it a little bit further.
Right.
And it just,
So the change in circumstance is basically that we feel differently now about wetlands,
yes,
essentially, right? That's
exactly.
really what it is.
Right. Yeah.
also, and taking that one step further, the application, it basically, it moves forward the change in the law. It's consistent.
Yeah,
with
I
the
agree.
change in the
I was
law.
just trying to
Yeah,
articulate.
no, it's
it,
fine. No, we kind of, we're thrown into trying to figure out two things at once, and thankfully, it's one leads to the next. So, I guess that leads to the last, well, unless anybody disagrees with that proposal, then I guess we can go straight into the questions and be able to come up with a recommendation right now tonight.
So can you just
Go ahead.
tell me exactly where, so I visited the site today, and there are the 59 and 61 have a bridge, I think the next property to the north has a bridge that is the wetland. It channels the rainwater through it. When I got to the red circle, the driveway is about the length of maybe a car and a half, and I didn't see any bridges or channels or anything. And I wonder what happens in a big storm when that water, I assume, goes towards the ocean. So where does it end up?
See that swath that starts under the D of driveway, and it's sort of blue hashed?
Yeah, see, that's the
That's the path of-
Cross down.
So the
And off to the
bridges,
right.
so the driveway bridges that are maybe just 10 feet from the road on the western side are, what is their purpose? They're not in a wetland.
Well, the bridge appears located here, which is in the wetland.
Maybe that's a bridge I can't see from the street.
I haven't been to the site, but
Yeah, but
culverts built under roadways are typically, they're the artificial structure that kind of maintains the connectivity between wet areas, right? So sometimes you'll see a culvert, you'll see wetlands on both sides. Like, where's the wetland? It's getting channeled under the roadway.
but I'm standing on the
So,
road
and-
in this picture. Sorry.
I think that what you're bringing up will be very important when these folks get to the stage of the process where they need a natural resource special permit to actually do the design of the driveway. And that's why one of Chris's conclusion statements was that wetland protection needs to be at the forefront of the detailed design, right? Because what is going on with this system, what's there now, interacts with it and protects it, how the construction protects the wetlands. Those are all very key considerations that the detailed natural resources special permit would examine. For us tonight, the question is, do we want to build a whole new bridge through this wetland system, or do we want to utilize what's there, leverage that to provide access to this third property? And that latter option is what we're recommending, makes good sense. And I would say the ZBA, I can't speak for them, obviously, but they're always asking applicants to look at alternatives, right, that minimize impact. That's the alternative that minimizes impact when done properly.
Great, thank you.
So do we agree that expanding the existing common driveway for 59 and 61 Seaside Avenue to also serve 63 Seaside Avenue is in the interest of good planning?
Yes.
Yes.
Okay. And will we allow 63 Seaside Avenue to share an existing common driveway with the adjacent properties, 59 and 61, pending confirmation that the property's owners would give formal consent
Yes.
all around?
Do we know about the owners of
Have they been
59 and 61?
They've indicated that all the property owners impacted would sign the declaration of the common driveway.
Okay.
Even 59, because
Yeah, as I spoke with the agent for the owner
Great.
earlier today.
Do they all have the same, the agent for the owner? So you're getting that from the agent for the owner? Okay, well, presumably she's giving you accurate information. All right, does the planning board require additional information from the applicant aside from formal consent from the applicable property owners to use the common driveway? And
Yes.
I think we just heard that.
All that, that's what we need.
That's what we'll, so we'll get that. And also, if you could, make sure, please, in the letter, that the planning board found the change in circumstances, because that's the prerequisite for everything we're doing. And that should be in the letter. Okay, very good. Next is Myers lot line modification. And Tina, you're going to cover that?
Yes.
Okay, and the applicant is also, geez, what is this, the end of the summer? Nobody's around?
I mean, maybe we should skip just for this gentleman because
Yeah, why don't we? Let's.
the rest of the applicants are not here. You can
Thank you very much.
Fine.
We're going to move forward to,
What is this
we're going to go into regular meeting for the moment to the old file map modification for Sean McGee, Suffolk County Tax Map 300-57-6-9
Me too.
and 10.
This one.
Thank you, Sam, again.
This is the one where they.
Tina
we
Lagaran
got-
for the planning
got an
department. Just
additional piece of
give me a minute.
documentation. Yeah, right. You are, Matt.
So, pardon me, sorry.
You're on.
This is the application for a UR modification for McGee located at 41 Roosevelt Avenue in East Hampton. This is requesting a modification to UR parcel number 18 and number 20, as shown on the old file map study number 121. You can see the parcels are outlined in red here.
Excuse me, you still have to share the screen.
Oh, thank you. Now you can see
Much
the parcels
better.
outlined in red. Thank you so much, Matt. Again, this is the old filed map study, map number 121. The two parcels outlined are 18 and 20. The proposed modification would create a lot that's 15,698 square feet. These two lots are currently located in the B residence zone, and both are non-conforming with respect to lot area size. The new parcel would still be non-conforming, but would be less so than the existing condition. As this represents a combination of two separate parcels, there's a decrease in density on this map, and the planning department has no objection to the modification for this reason. The town consulting engineer also reviewed, and those were his findings as well. If the planning board is supportive of the amendment, then a recommendation memo would be prepared for the board to send to the town board to formally act on the modification. Thank you.
So all we're being asked to do tonight is to give a recommendation to the town board as to whether or not we support this application. Does anybody have anything they want to add?
Nope.
No.
Supportive.
Do we
Support it.
all agree that this application should be supported and
Yes.
recommend that to the town board?
Yes.
5-0. There you are. Okay, thank you very much. Sorry to hold you up as long as we did. Okay, you too. Thank you, Tina, for reminding me. All right. And now let's move into
Myers.
Myers, yeah. That's yours, right?
Yeah. Okay. The Myers lot line modification. This was an application. The public hearing was held. The public hearing was not held. The board waived the public hearing requirement for this application because of its minor nature. I am going to bring up the survey to share with the board as a refresher. This was a change in a lot line that resulted in lots that more accurately reflect the existing conditions for these properties. And the end result was two lots that had the same size they did when they started. They were just slightly reconfigured. So you see this green line represents the change, really a de minimis change to both of these lots. And there were no public comments or comments from the fire marshal that were of concern. And we do have a resolution of approval on, provided the board is accepting of this proposal.
Very good. Thank you, Sharon.
Yeah, no, we all were made consensus that this made sense. It's basically, the line was changed to the existing conditions. The hedge is there, the way it's now being parsed out. It's, families, they're next to each other. They're owned by, family members. And that's why I think we waived the public hearing. And I move to go forward with this.
Okay. Anybody have any other comments on this?
Nope,
You want
looks
to
good.
do the
Yep,
motion,
yep.
which is right here if you want?
I have it. Okay, yeah.
Okay, yeah, go ahead. Yours, mine.
Okay, in the matter of the application of Myers lot line modification, tax map number 300-161-5-10.1 and 11. This is a lot line modification, and I have read this resolution and move for its adoption.
Is there a second?
Second.
All those in favor?
Aye.
Passed 5-0. Okay, very good. Next is, what should we do next? Should we do Ranger Estates or Faro?
I just pulled up Ranger Estates.
All right. Then that's what we'll do next.
Thank you.
Dealer's choice.
This is also a wrap-up discussion for Ranger Estates. A public hearing was held on August 14th. No members of the public spoke and no written comments were received. The hearing was closed on the date it occurred. The fire marshals reviewed and found it acceptable. The application was to modify the building envelope. The board may recall there was a builder error that resulted in a small part of the garage being constructed outside of the approved building envelope. The applicant, instead of reconstructing their garage, offered a significant change to the building envelope that reduced its size by 711 square feet. So it resulted in more protected area than the original proposal. Based on that unique situation, even though there was no change in circumstance, the significant mitigation offered, the board was accepting of this proposal. So there is a resolution on to approve this as well. The resolution, I think, does need a little bit of modification to note the significant departure, significant give back that the developer proposed in order to get this approved.
We'll wordsmith it up here.
Okay, great.
Okay. That's the one that I have.
Okay, yeah.
Okay, you're going to cover this?
mean,
Did you
want me
want
to?
it? Well,
Sure.
if you don't, yeah.
No.
I was going to do Pharaoh or you were going to do Pharaoh? We're covering the ones with Jen, yeah.
I can do it.
All right.
I mean, I was
All right,
gonna
it's all on you. It's all on you.
Yeah, so Ranger Estates, I think Tina pretty much summarized, how we came to our decision. They had already built the garage. It just would have not made sense to have them tear it down for that, small corner. And so we just, they offered, the reduction in building envelope, and it made sense. So I'm good with it. Everybody else is.
Yeah, if you recall that, look, we don't want to encourage, and in fact, we want to strongly discourage that when the builders get out there, they kind of do audibles of their own without checking with the planning department, the building department, or the planning department, or anybody else. And ordinarily, this might be something that we might not approve. But given the significant nature of the concession which reduced the building envelope, which is the language I'm going to suggest be added to the resolution, I think it's a good idea.
Yeah, I think it's important to have that language.
So is that
I would
language?
even argue it was not an audible, because audibles are drawn up before the game starts.
Showing my ignorance of football, which I carry with me as a Jets fan, so. And Ohio State. All right, so you want to read in the or
Sure,
not approve of the resolution with the
Without,
addition of that
Okay.
fancy language.
In the matter of the application of Ranger Estates final subdivision, Ocasio, tax map number 300-189-1-4. This is a resolution to amend a previous approval. So the added language in the proposed amendment would be to, instead of the result in overall decrease in building envelope area, significant nature of the concession which reduced the building envelope would be the new language right here.
That's, or additional to that.
Yeah.
All those in favor of the
Aye.
resolution as modified?
Second.
I'm sorry, you're right. She moved.
Second.
There we have a second. Okay, all those in favor?
Aye. Aye, all good.
Yes, 5-0. Okay.
Attached, give that to
You want the
you need this?
scribbled version of it?
Give that to Jody.
Thank you, Jody. Okay, and then finally, we have Faro Beach. And again, the applicant isn't here on that one either.
Wow.
And the applicant knows about this being?
Excuse me, planning board. I
Yes,
now
we have
have
somebody waiting for us?
I now have somebody waiting in the waiting room. Yes,
He-
D. Rizzo.
Yes, that's fine. He can, let him know that we know that he's there, and we'll be getting to him momentarily.
Okay, I'm
Okay.
gonna let him in, and then we'll tell him.
That's fine. That's fine. Okay.
This is the application for Faro Beach. This is also a wrap-up discussion. This application had a public hearing in March 2024. I'm sorry, March 2023. 2024. What's wrong with me?
2024.
March 2024. And the hearing was left open pending the resolution of comments on the revegetation plan. Written comments were also received asking that the board require revegetation of the area that had been formerly used as the second driveway, which was not approved by the zoning board in the NRSP and variance review. Here is a look at the latest site plan to refresh the board's memory. Since the last time the board saw this application, the revegetation plan has been enhanced and modified both in the area subject to revegetation as well as the species mix to be utilized to do the revegetation. And the planning department is accepting of this. The applicant and the planning department agreed to this proposal, so we recommend the board agree as well. And then the applicant has also submitted this plan, which I'm zooming in on the second driveway. They submitted the letter from the town highway department accepting the revegetation of that area. With those two additions to the plan, since the board last saw it, we recommend that the application is complete and ready for approval. We do have several substantive conditions of approval that we wanted to discuss with the board before proceeding to drafting the resolution for their consideration. The first two listed in the report are standard, approval from the ARB for, changes to commercial structures and submission of the site plan containing the Suffolk County Department of Health approval. This application did involve an upgrade to the existing septic system, which is a definite positive benefit of the application. The first condition of approval would like to seek the board's concurrence on is that the planning department recommends that the single-family home on site be subject to the requirements of the Chapter 199 rental registry. The board may recall this is a commercial establishment located in a residence zone. It's a pre-existing non-conforming use. There is a single-family home on site that used to be owner-occupied. We do understand, based on public comment and other feedback, that it is no longer owner-occupied because an expansion of the commercial operations to this structure would substantially be an expansion of the commercial use to that structure. We recommend that's not appropriate based on the non-conforming nature of the use, and that the Chapter 199 rental registry, which applies to everybody who wants to rent their home, be used to govern how that piece of the property is utilized. We recommend that covenant should be mapped so it runs with the land and that it's filed prior to the certificate of occupancy. The next condition is the implementation of the revegetation program, which would be inspected by the planning board or zoning board delegate prior to the certificate of occupancy, as well as the revegetation of the former access drive, which also requires inspection prior to CO. And then we do need the required number of copies. We don't seem to have all the copies in our file of this final site plan. And that's it.
Thanks very much. Yeah, my view of this is that in the first place, I'm very glad that having kept the record open, we received a comment regarding revegetation of the driveway and that the applicant complied essentially with the request that was made in the public comment. So that's very good. And also of significance is the requirement of the registration of the single family residence, because that was, as I recall from our discussion on this matter, that was a real sticking point. Yeah. We were concerned about increasing density, and this will hopefully prevent, assuming the law works the way it should, prevent that from occurring. So I'm all aboard with approval on this. Anybody else has any comments or questions or
good to go
reservations?
Good to go.
Okay, so are the conditions of approval acceptable or are other conditions needed?
No, these are good.
No, these are good.
Yes to the first, no to the second. And is the application ready for approval?
Yes.
There you are. Okay, All right, so we have now gone through the entire work session and regular meeting. I'm going to, in a moment, I'll move to approve the minutes. And then after that, Nancy, I want to make sure we do this right. We're going to move to close the meeting. That'll give Jody the ability to go home
Right, a motion to close the meeting and to consult with.
and then consult with council. Before we do that, and before Jody leaves, we all have our vouchers. And they should be in our packages. Make sure that before Jody leaves, you give Jody your signed voucher, right? That's the way we do these things, right?
Yeah.
Okay. Michael. Did you give yours in?
I came early.
Head of the game. All right, very good. Okay, so I'm going to do the minutes, and then do we need to make a motion to close the meeting?
Yeah, after you do the minute, yeah.
And go into?
Yeah, right. Yeah.
Okay, very good. I'll do that.
The one motion to cover those things.
All right, okay. All right, I've read the minutes, and they are fine and reflect our last meeting, and I move for their approval. Is there a second?
I'll second that.
All those in favor?
Aye.
Pass 7-0. Okay, now, I move that we close the meeting and go into attorney consultation. Is there a second?
Second.
All those in favor?
Aye.
Okay, the meeting is now closed. Thank you, LTV. And is Mr. Russo on our screen yet? There he is. Okay,
Okay,
Dan, did we
but-
do that right?
Okay.
Yes.
Planning board,
Yes.
before you go, it sounded like you just made a change in audible here. You're ending the meeting totally and then going into your special meeting?
That is correct. And you are going to not listen.
That's correct, but I can
Dan,
end the broadcast then, right?
Yes. Yes, absolutely. Yes.
Yes. Okay. So give me a couple of seconds, please.
Very good.
You said you audible.
Yes, I know. Now it's a verb.
Sorry, I'm a Giants fan.
Right, all right. Yeah, you're fine. Well, Tina will reach out to you when we're, all right.
I guess let's ask Matt. Matt, if we just leave the meeting, is that all we need to do? Because if you don't need to stay, if we can just,
Well, he has to stay to keep the camera on.
oh, he has to stay to leave Dan in,
Yeah,
right?
he's managing that.
But I'm saying if we all left the meeting, would it end?
If a meeting, if a meeting.
I will stay. Sam, I will stay. I'll just stay and then we'll leave the meeting.
Very good. Jody, thank you
No
very much
problem.
as always.
All right.
Jody.
Give me another second, Sam, please.
Sure, no problem.
March 2024. March 2024.